We are going to go ahead and deliver the opening remarks here. Thank you to all of those of you who were able to make it in person today, as well as those joining us on Zoom. Let me introduce myself. My name is Noah Richardson, and I am the editor-in-chief of the Minnesota Journal of International Law. In partnership with the Human Rights Center, we're very excited to deliver this symposium to you today. We have a wide range of topics, some very engaging speakers that I personally am very excited for us to have. There will be additional opening remarks from our faculty advisor, Professor Roberts. But before we begin, I just wanted to extend some thank yous. Firstly, to our journal Symposium editor, Megan Marvin, for working so hard to put this all together, as well as Professor Lyons and Abby Nelson at the Human Rights Center here at the University of Minnesota Law School. Without their help, none of this would have been possible. And then finally, thank you to all of you for attending. The rule of law and the judicial system, both at home and abroad, is having quite a moment right now, as I'm sure many of us are aware. So engaging in these kind of conversations where we can discuss solutions and practical guidance for practitioners and anyone else who might care about these issues is a very, very important thing for us to do. And again, I want to thank you for joining us. Without further ado, I'll turn it over to our faculty advisor, Professor Roberts.
Thank you, Noah, and I want to thank the journal and the journal editors, Megan, for putting together this conference, and the folks at the Human Rights Center who have been an indispensable part of this process. In preparing for these brief remarks, I was thinking to myself, what is the main issue that we want to think about, that we want to talk about, that we want to consider in the context of the theme for this symposium? And my mind went immediately to a chance meeting I had with a former student yesterday at a pub in North Minneapolis. And the student was one of my students about 10 or so years ago, and came up, we reintroduced ourselves, and he asked a question. The first question he said was, how are the students doing now with everything that's going on? Are they disillusioned? And he used that word, disillusioned. And I said, yes, I hear that word a lot. And in particular, in my international law class, where every reading assignment we have, we read about all sorts of human rights violations. We read about international crimes against humanity. And then as we get through the readings and we read the resolution that the editors put at the end of the cases, the resolution is oftentimes there hasn't been accountability, or the accountability that we had hoped for hasn't been as strong, hasn't been as robust, it hasn't been as definitive as we would have liked. And even though I don't hear the word disillusioned, I can see it on the eyes and the faces of my students. What do we do when we know that there are wrongs that are happening, and we also know that we're not doing what we need to do to hold those who are committing those wrongs accountable? I went back with my student. We kind of talked a little bit about what we covered in class 10 years ago. And there was this exercise that I did with those students, and it was called the problem of problems. We created a Google Sheet, and every student in the class, it was a seminar, so 15 students, opened their computers, and we had a spreadsheet. And I said, I would like each of you to list as many problems as you can on this shared Google document that lists problems, not just little problems, but huge problems huge problems that we are facing today. This was 10 years ago, by the way, when things were comparatively more stable. Uh, Huge problems that we don't have answers for yet. And in 10 minutes, the 15 students listed more than 100 unique major problems that we're facing today. And if that's not something that causes a little downheartedness, I don't know what. But I think there's a way that we can look at this. And with that list of 100 problems, unique problems, I asked the students to consider what those individual problems are and what the big problem is that perhaps captures and puts a ring around all those smaller problems. And so in that sense, we have two problems. There is the big problem, put it in all capitals, we'll call it the capital problem. And then we have the lowercase problems, the smaller problems that fit inside that capital problem. As we listen to our speakers today, I encourage all of you to think about what is that big problem, that capital problem that we can put these smaller problems that each of our speakers are talking about in. And if we can figure out what that capital problem is and give that capital problem a name, we have one problem, not 100 problems, not 1,000 problems. And perhaps we can unite a little bit better on these issues and not take them one by one by one by one alone, but take them one by one within the context of that bigger capital problem. How do we do that individually? I have this phrase that I use with students. It's implicated, but not to blame. Ask yourself how you might be implicated in the problem you wish to address. And when I say implicated, usually when we say implicated, we're thinking about somebody who has done something wrong, somebody who has something, some wrongdoing associated. I'm not talking about implicated in that way at all. I'm thinking about the word implicated, meaning how might you be embedded? How might you be immersed? And the etymology of the word implicated is helpful in that regard. It comes from the Latin. There's the im, means to place in, and then placare, which means to be woven into. So how might you be woven into the actual problem that you wish to solve? And we see today all of our speakers have somehow woven themselves into the fabric of the problem with which they want to focus on. And within that position, when you are actually woven into the problem yourself, that is a position of power. That is a position where you can do something. You are not looking from the outside saying, hold those people to accountability. Those people are bad. Those people are wrong. You are bringing yourself into the problem itself. And to do that often takes a degree of vulnerability that perhaps we're not used to within the practice of law. And I want to give you a brief example that I talked to some students about the other day, but it's how I'm implicated in gender violence issues in a way that I didn't even know 10 years ago when I had that student I met at the bar as a student. And in class, we were talking about, so we sort of went on a sidetrack and we were talking about walking through a parking lot at night on campus. And one student said, oh yeah, whenever I walk in a parking lot, I've got my keys in my hands. Stick somebody in the eye if they try to do anything to me. And it was a woman. And I said to her, and this is me being dense, me being completely unaware. I said, do you do that every time you walk in the parking lot? And she said, yeah, of course. And then one by one, the other women in the class talked about what their strategies were to avoid physical violence, to avoid rape, to avoid being attacked. One woman held up her pepper spray. Another talked about self-defense. And then they started trading examples of what type of self-defense they've taken and all the men were silent. And my eyes were opened to something that I should have known but didn't know. My consciousness expanded in a way that was profound. And we talked about that for a while. What do I do when I go in a parking lot? Well, I'm thinking about what I ate for lunch. I'm thinking about what I just read. I'm thinking about a TV show that I want to watch. It's a completely different experience. And so in that sense, when we're thinking about gender violence, there are the horrible crimes that we focus on, but there's a pretext and there are priors to those horrible crimes of cluelessness, of pretending that there isn't a difference between the experience of men and women on a daily basis, not just in countries over there, but here as well. And so in that sense, the idea of the problem of problems becomes not necessarily problems out there, but problems within here that we all have to grapple with. And I think that the editors of the journal have chosen this topic, have done an amazing thing to help us in the law school and to help those who are here who are in the audience and those who read the articles recognize that this is a problem not just out there, but it's a problem that we need to address here within our walls and to be able to work together for a common cause and think about what that big problem is, that capital problem. I'm going to pause there and turn the lectern over to the next panel. But I want to thank you all for attending, and I'm looking forward to a fantastic event. Thank you.
Good morning, everyone. My name is Megan Marvin. I'm the Symposium editor this year at the Minnesota Journal of International Law. We'll be introducing our next session, which will be a conversation between Professor Ranjita de Silva de Alves and Professor Colleen Bell about the Women, Peace, and Security Agenda from the CDAW Committee. Colleen Bell joins us today from the University of Saskatchewan, where she is an associate professor, graduate supervisor, and faculty member in political science at the College of Arts and Science. She's an international relations scholar, most recently specializing in decolonial and feminist theorizations of war, security, and interventions. Professor Ranjita de Silva de Alves is a world-renowned international legal scholar and women's rights expert from Sri Lanka who joins us today remotely. She currently serves as the senior adjunct professor of global leadership at the University of Pennsylvania Carey Law School, as well as serving as co-chair of the Women, Peace, Security Agenda for the CEDAW Committee at the UN. She recently authored an addendum to the Women, Peace, Security Agenda that was adopted at the 92nd session of the CEDAW Committee. We're very grateful to have her as a part of our event today, as she brings untold expertise in these topics. Thank you both for being here today, and Professor Bell, I'll hand it over to you now.
Thank you, everyone, for being here. It's lovely to meet you, Ranjita, if I may. So I'd like to, first of all, just congratulate Ranjita on an incredibly important contribution to the Women, Peace, and Security Agenda. And I think in some ways, this addendum comes about in a moment of maybe what I'll refer to as striking paradox. On the one side, important progress has been made in the women, peace, and security world, and I think the addendum is definitely a testament to this progress. But I think, obviously, we also see progress in other areas of intellectual growth around women, peace, and security. I teach a seminar at the University of Saskatchewan called The Politics of Security, and we just completed a section on WPS. And, you know, one of the things I'm struck by, I've done this a couple years in a row, is just the burgeoning literature with very thoughtful critiques that really push for deeper and more meaningful intersectionality in the Women, Peace, and Security Agenda, and seek to better account for multiple overlapping and complex forms of oppression. And also, I think, which is important from my perspective, because of the interest I have in Canada's National Action Plan on Women, Peace, and Security, the kind of, if you want to say, neo-coloniality of the global north, especially with respect to national action plans. And I think this also applies to the United Kingdom, for example, where there's kind of this consistent positioning of the problems that are named in the National Action Plan as largely external to themselves. So Canada tends to position many of the problems that it identifies as happening out there, and then as having solutions to those problems for others, and doesn't do a lot to consider, for example, the crisis of murdered and missing Indigenous women and girls, which is a huge issue in Canada. And as well, the kind of role of security forces, the RCMP, for example, the Royal Canadian Mounted Police, in being implicated or even maybe to blame for some of those issues. So that's kind of one side of the paradox. And I think, maybe the other side of the paradox that the Women, Peace and Security finds itself in is, what I'll just state rather pointedly, a kind of depraved nightmare of human suffering and genocide that's around us, where international law isn't even a consideration in the decision-making among many of the most powerful states in the world, and many states that are currently engaged in military operations. And, as we learned this morning, even the Pope isn't spared. So I think much of what's outlined in the addendum and many of the issues surrounding the Women, Peace and Security agenda that have emerged, I think charts a path forward to try to give us some hope, to try to make the work of international organizations hopefully more relevant, even while they are largely dismissed by particular actors in the world. And so this is all to say that I do think that even in these difficult times, we still need to have some hope. And I think the addendum offers us that. So without further ado, Ranjita, please take it away.
Thank you. Thank you, Professor Bell. Thank you to the editors of the Minnesota Law School's Journal of International Law for convening this symposium at a critical moment. And as the journal's distinguished faculty advisor reminded us, accountability, especially for gender-based crimes, is the major challenge of our time. I'm Rangita De Silva de Alves. I'm the Distinguished Adjunct Professor of Law and Global Leadership at the University of Pennsylvania Law School. I also serve as an expert on the committee to the Convention on the Elimination of Discrimination Against Women, and I'm the chair of the Women, Peace and Security Agenda, as well as the chair of the Optional Protocols Individual Complaints Mechanism. We come together at a time of new and continuing conflict, when the international rules-based global order itself is under threat and multilateralism is at risk. The Women, Peace and Security Addendum to General Recommendation 30 of the Convention on the Elimination of Discrimination Against Women that I was honored to draft responds to the changing face of war. However, the face of war remains a constant. It remains masculine from Yalta to 2026. Cicero, Rome's great orator and statesman, famously stated that in war, the law is silent. Is international law silent in times of war, despite the fundamental, universal, and inalienable guarantees? Lauterpacht has famously said that international law is at the vanishing point of law. As you know, he was one of the most influential international lawyers of the 20th century. If international law is in some ways at the vanishing point of law, the law of war is perhaps even more conspicuously at the vanishing point of international law. As Hilary Charlesworth, who is a jurist on the International Court of Justice, famously wrote, almost all international law is created by men. And that is why CEDAW's addendum stands at an important inflection point to change the image of international law. The Charter of the UN's first stated mission is to save succeeding generations from the scourge of war and to reaffirm faith in fundamental human rights, in the dignity and the worth of the human person, in the equal rights of both men and women, and of nations large and small. Today, we are in the grips of some of the deadliest conflicts and crises. We also come together at a time of the reversal of generational gains of women's and girls' human rights, a backlash against feminism, threats to the rules-based global order, and the shrinking of the civic space, which continue to have a chilling effect on women and women human rights defenders. The political economy of conflict. While global military spending rose significantly in 2024 to an all-time high of 2.7 trillion, women's health care remains underfunded. This figure of 2.7 trillion represents a 9.4% increase in real terms from 2023, the steepest year-on-year rise since the end of the Cold War. As said once by Lyndon B. Johnson in his Give Peace a Chance speech, every gun that is made is a theft from those who hunger and are not fed. 77 years after the Universal Declaration of Human Rights, we are at a point when we must once again reaffirm our commitment to international law, including international humanitarian law and international criminal law. 25 years after the Security Council Resolution 1325 called for the categorical right of women's leadership in peace and security, the addendum to General Recommendation 30 builds on 1325, but it also addresses the burgeoning threats posed by cybercrimes, algorithmic bias, climate emergencies, and the shrinking of civic space. The addendum itself, I have to admit, faced a strict word count of 9,630 words because of the economic crisis at the United Nations. The economy of the word limit, to a large extent, limited the ways in which I could give thought and voice to these burgeoning threats and risks. I will pick a few elements of the addendum this morning to address what I think are some of the most important risks that we need to address. The addendum first pierces the veil of impunity. Impunity is history's greatest shame, and the shadow of impunity continues to loom large. Sexual violence is still the oldest and least condemned crimes and remains history's greatest silence. The world's collective inaction has ushered in an age of impunity. And addressing impunity, the addendum first looks at a survivor-centric access to justice approach, both in transitional justice as well as in reparations. And the reparations are defined to include not only material reparations, but moral and transgenerational damage, and structural and institutional reparations, as well as the preservation of historical memory. Reparations are not only criminal in nature. The call for never again consists of transformation, political, legal, social, and cultural. In the Shakespearean tragedy Titus Andronicus, Lavinia, the rape victim, has her tongue cut and her hands cut off by Chiron and Demetrius to prevent her from identifying them after she is raped. Shame and stigma and silence in law still force women's silence. Accountability efforts must give women an opportunity to claim their voice in court, to tell their narratives and to reclaim their dignity, especially in cases of conflict-related sexual violence, including sexual slavery, forced marriage, and forced pregnancy. Article 68 of the Rome Statute calls to take appropriate measures to protect the safety, physical, psychological, and the dignity and the privacy of victims and witnesses, to honor women's stories and to reclaim their dignity through accountability mechanisms is what constitutes a survivor-centric approach to access to justice. Nowhere is accountability as important as to the women of Afghanistan under the Taliban rule. In July 2025, the ICC issued warrants of arrest against leaders of the Taliban, representing the first time that the prosecutor charged the crime of gender persecution on its own. The ICC maintains that there are reasonable grounds to believe that there exists a crime against humanity under Article 7(1)(h) of the Rome Statute of persecution on the basis of gender, targeting not only women and girls, but also those who are perceived as their allies. This opens the door for gender persecution as a standalone charge in the fight against impunity. In the very first exercise of the CEDAW's Article 29, the Dispute Settlement Clause, the jurisdictional clause, called forth under Article 62 of the ICJ, Australia, Canada, Germany, and the Netherlands to come forward as pen holders to hold the Taliban accountable. After a period of negotiation and arbitration, there is hope that this might be filed before the World's Court. The right of states to intervene is guaranteed under Article 62 of the ICJ statute. Should a state consider that it has an interest of a legal nature which may be affected by the decision in the case, it may submit a request to the court to be permitted to intervene. Right now, we have over 20 states who have come forward to support the role of the pen holders, but we need more countries from the global south to come forward. State and non-state actor responsibility is writ large in the addendum. As we all know, along with the rapid growth of the military industry complex, the illicit trade of small arms and light weapons threatens global peace and disproportionately affects women and girls. In 2024, the UN Secretary General stressed that arms transfers serve as early warning of conflict-related sexual violence. UN Security Council Resolution 2467, which is the Access to Justice Security Council resolution under the corpus of the Security Council Resolution 1325 and its nine Security Council resolutions, calls upon exporting states parties to take into account the impact of the arms trade on gender-based violence. Article 7(h) of the ATT, the Arms Trade Treaty, mandates that states assess the risk of exported weapons being used to commit serious acts of gender-based violence, requiring a denial of transfer if an overriding risk exists. Unfortunately, the Arms Trade Treaty is not read in light of Article 7(h). The role of extractive industries, including conflict minerals such as 3Ts and G, tin, tungsten, titanium, and gold, have been mined to meet the dizzying speed of the AI arms race and the rise of the global tech industry. However, the Dodd-Frank Act of 2010, which addressed the US financial crisis of 2008, within the Dodd-Frank bill, nestled within this vast bill is Section 1502 of the bill, which imposed on businesses additional reporting on trade in conflict minerals, which helps to finance conflict, particularly sexual and gender-based violence in the Democratic Republic of Congo and adjoining countries. I'll now go on to what is probably one of the most salient issues of the addendum, a new realization of educational violence. As Margot Wallström, the former Minister of Foreign Affairs and the architect of feminist foreign policy, she was the Minister of Foreign Affairs of Sweden, as well as the renowned architect of feminist foreign policy, observed in a piece that she and I co-authored for International Women's Day last month, it is more dangerous to be a woman fetching water in conflict zones than a soldier in the battlefield. But I argue that women's bodies are not the only battlegrounds of conflict. Their minds are battlegrounds too. While war continues to be waged on women's bodies, as Raphael Lemkin once said, war is not carried out by arms alone. Weapons are not the only tools of war. Women's bodies are not the only battlegrounds. Their minds are battlegrounds too. I often ask, what is it about a girl with a book that so frightens a man with a gun? From Malala to girls of Chibok in Nigeria, to the LRA attacks on the Luwala girls' schools in Uganda, to the deliberate, intentional, and systematic denial of girls' and women's education in Afghanistan, there is a war against girls' education. The Geneva Conventions, the laws of war, prohibits the destruction of civilian property, including educational institutions. UN Security Council Resolution 2601 condemns the destruction of civilian infrastructure, including schools, the military occupation of educational institutions, and the attacks on girls and women traveling to school. Education is not only about math and science and language, it is also about learning to create peaceful communities. UNESCO's 5 pillars, nestled within those 5 pillars is an articulation that education for sustainable development initiatives outline the capacity that education provides for women and men, girls and boys to learn to know and to learn to transform oneself and society. As UNESCO has stated in its constitution, war started in the minds of men. Since wars begin in the minds of men, it is in the minds of men that the defenses of peace must be constructed. So when I ask the question, what is it about a girl with a book that so frightens a man with a gun? The answer is that an educated woman, an educated girl, is the biggest threat to fundamentalism, extremism, and misogyny of all sorts. I have written widely about the right to education, the totality of the chilling edicts of the Taliban, numbering over 100, targeting women and girls, constitute a crime yet to be named. No other country in the world denies the fundamental guarantee of education to half its population. No other country suspends due process for half its population by banning women access to justice. During World War II, Winston Churchill called the mass killings of innocents a crime without a name. Raphael Lemkin responded by coining the word genocide. Once again, I argue, we must name a crime that strikes at our consciousness and our common humanity. The denial of education and intellectual aspirations of half of Afghanistan cannot be condoned as part of religious ideology. We need to avoid falling into the trap of cultural relativism that somehow some women in some places, because of some cultural differences, have different standards of justice, including unequal rights for women. That is an intellectual conceit that we need to avoid. Can we see culture as heterogeneous and internally contested rather than primordial entities? Can we challenge the concept that culture is immutable, stable, true, even absolute? Norms that discriminate against women are most often legitimated at the altar of culture, religion, and tradition. Although the International Convention on Civil and Political Rights and the Universal Declaration of Human Rights guarantee the right to hold religious beliefs and practice a religion of their choosing, international law permits states to impose limits on the practice of religion, which are necessary to protect the fundamental rights and freedoms of others. Therefore, I argue that restrictions may be imposed on religious law and practice if they are necessary to protect women's human rights and fundamental freedoms. And this is enshrined in General Comment number 28 of Article 18 of the ICCPR. Although the ICCPR Article 18 guarantees freedom of religion or belief, General Comment 28 to Article 18 says that this may not be relied upon to justify discrimination against women. And the CEDAW Committee's General Recommendation number 36 on education notably sees education as a legally justiciable right, and it recognizes rights in education as legally enforceable. and that upon the violation of those rights, girls and women have equal and effective access to justice. Of special interest are the speakers who come after me today. Your own distinguished professor, who was the special rapporteur on preserving human rights while countering terrorism. I have used this as part of my addendum so that we understand that women and women human rights defenders cannot and should not be in any way instrumentalized in countering violent extremism or preventing violent extremism. Nor should CVE and PVE be addressed in a way that demonizes ethnic minorities, religious minorities, or different genders. The WPS agenda's UN Security Council Resolution 2242 on countering violent extremism and preventing violent extremism must be dealt through the CEDAW's international human rights guarantees in a way that women's human rights defenders participate in the prevention of violent extremism but are not weaponized or instrumentalized in these efforts. Moreover, the domestic interpretation of the Security Council Resolution 2242 must avoid gender, racial, religious, and ethnic profiling. As for culture, my friend Karima's work on UN Security Council Resolution 2347, which condemns the unlawful destruction of culture as a war crime, Karima continues to address this not only as a war crime, but that she argues that the building of peace, the maintaining of peace requires adherence to culture and the celebration of culture. And she encourages a fully gender-sensitive approach to the protection of cultural heritage. And the addendum to the WPS and the addendum to GR30 is fully in line with UN Security Council Resolution 2347. I now finally go on to AI in warfare. The age of AI has been likened to the Greek myth of Prometheus, who stole fire from the gods. The theft of fire symbolizes the acquisition of knowledge or technology for the benefit of humanity, but it also has the power to burn and destroy humanity. AI, like the gift of fire, is a double-edged sword. AI mistakes are often patterned, reflecting patterns in the training data, algorithms, or the AI's fundamental design. Yale Law School's Una Hathaway's recent arguments on individual and state responsibility for the patterns of mistakes in war may also apply to what I argue the patterns of biases in AI-driven lethal autonomous weapon systems. In current and future disputes, machines do and will continue to make life and death decisions without the help of human decision-making. I ask in my latest article that was published by the Chicago Law Journal, Chicago University's Journal of International Law, who will then be responsible for the mistakes in war committed by AI-driven lethal autonomous weapons? Although much has been written about algorithmic bias, an algorithmic divide can create an AI-driven weapons asymmetry between different nation states depending on who has access to AI. In the final analysis, I argue that the transformative potential of AI must be harnessed not in conflict, but in conflict prevention and in conflict resolution. During the 2017 testimony to the U.S. Senate Armed Services Committee, then Vice Chairman of the Joint Chiefs of Staff, General Paul Selva stated, "Because we take our values to war, I do not think it's reasonable for us to put robots in charge of whether or not we take a human life." Today's New York Times compares the global AI arms race to the dawn of the nuclear weapons age. A majority of states who were brought together by the Secretary General for a resolution argue that lethal autonomous weapon systems that cannot be developed and used in accordance with international humanitarian law are inherently likely to discriminate and therefore if lethal autonomous weapon systems that operate outside human control cannot comply with the international humanitarian law principles of distinction. And this principle calls for distinguishing between civilians and combatants. And secondly, the principle of proportionality, which calls for a degree of empathy to understand whether harm to civilians would be proportionate to the goals of self-defense. And finally, the principle of precaution, which is a particularly nuanced principle, which calls for not only obeying orders, but disobeying orders. And would AI be capable of disobeying the data on which it is fed on which it is trained on? So, for example, the Nuremberg defense, which was rejected at the Nuremberg Military Tribunal, could there be a Nuremberg defense in terms of AI-driven lethal autonomous weapon systems? Would AI-driven lethal autonomous weapon systems be in a position to refuse to obey the wrong and faulty data? Large language models, as we all know, are trained on historically biased and gender discriminatory data. Data is not inherently neutral. Data control itself is a form of power. Large language models are trained on vast quantities of data, and the bias in the training data is baked into algorithms, leading to algorithmic bias and automated bias. Scholars have highlighted the garbage in, garbage out problem in training data sets for AI, showing how the lack of diversity in the data sets can result in mistakes in war. So when Una Hathaway asked who is responsible for mistakes in war, I bring this question to a larger issue of AI-driven lethal autonomous weapons. Who will be responsible for algorithmic mistakes in war? The next 25 years will see enormous change. Artificial intelligence will make conflict more lethal. AI-enabled cyber attacks and AI-enabled decision-making will transform conflict and develop new tactics of warfare. The emergence of new challenges include maritime security, the space race, and the militarization of space. The addendum also calls for the accountability of, as I said before, state as well as non-state actors, including transnational actors, to exercise due diligence in conflict prevention as the bedrock of the Women, Peace and Security agenda by addressing historical power structures. In terms of the new resolution that the Secretary General has urged, the new convention to address lethal autonomous weapon systems that operate outside of human control, the European Union supports a two-tier approach with a distinction made between those weapon systems that cannot be used in accordance with international law and international humanitarian law. Regarding risk mitigation and confidence building measures, the EU recognizes how the use of data in AI technologies can cause social biases to have potential impact on emerging technologies, and thus urges that risk mitigation measures should be adopted. A primary concern for Canada, the previous professor who is in this conversation with me, did speak of Canada's Women, Peace and Security National Action Plan. A primary concern for Canada is the potential for the inclusion of unintended or intended biases in the development and programming of autonomous functions in weapons. And Canada is concerned that fully autonomous systems may not be consistent with the principles related to the Women, Peace and Security agenda. I have studied all of the 193 country submissions, and Canada is one country that races to the forefront of compliance not only with international humanitarian law, but with the Women, Peace and Security agenda. So kudos to Canada. Fiji speaks of battlegrounds for the testing and deployment of these weapons, and the power imbalances which allow, I quote, the rich countries to use these weapons against the poor. Fiji also highlights the environmental harm and the development and use of autonomous weapons and how this would create greater harm to the environment. And Kiribati, this tiny island, a small island developing state in the Pacific, states very poignantly that it has experienced 33 nuclear weapon tests on its islands, and that it's alarmed about the potential use of autonomous systems in nuclear decisions. Thus, Kiribati demands that nuclear-armed states never allow autonomous weapon systems to control their command and control systems, and that they ban nuclear weapons. I began with the statement that GR 30, General Recommendation 30's addendum, responds to the changing face of war, from climate emergencies to AI in lethal autonomous weapon systems. But one thing, as I said before, remains constant. From Yalta to the present, the face of war is male. I did send earlier in the morning 2 photographs that I wanted to share with you, but I think due to technical problems, those cannot be on the screen. At Yalta, what we saw were men, and in 2026, what we see is a disproportionate number of male leaders with 2 women on this photo of the Council of Peace that was brought together by the Trump administration. So international law is man-made. How do we reclaim? How as women scholars, women activists, how do we reclaim international law? As Hilary Charlesworth and Christine Chinking have argued, women's voices and perspectives have long been absent from international lawmaking, existing only in the margins of international law. The resulting silence signals that women are not makers of law, especially international law. Until the adoption of the Convention on the Elimination of Discrimination Against Women, the reality was that women's perspectives were missing from the formal international human rights discourse. The CEDAW is therefore significant not only because it enshrines women's rights, but also because it insists that the equal participation of women in the international legal system and its institutions is a condition of the legitimacy of international law. Thank you.
Thank you so much for all of those comments. My notes I took a lot of notes and they're kind of a mess, but I did prepare some questions in advance. So I'll kind of move through them, not necessarily in the same order, and you can sort of pick up, what you think you can respond to. So I guess the first question that I wanted to pose is, the addendum speaks about gender apartheid. And it strikes me that this is like an incredibly important and potentially valuable concept. But I also, wondered if some of the responses that one might get is like, why not just talk about gender inequality or the discrimination against women? So I wondered if you could just talk a little bit about, from your perspective, what is uniquely important about the idea of gender apartheid and why speaking in those terms is important and helpful in some way, given the current situation. I guess I'm thinking a lot about the Taliban right now.
Thank you. So as you know, giving name is important if we are to hold the Taliban accountable, that a crime without a name cannot really be used in a court of law to hold the perpetrators accountable to that crime. And I have argued that gender apartheid is on an infinitely larger scale than gender persecution. And this is an institutionalized regime of oppression. So what I have argued in lots of my writings is that the crime of gender apartheid borrows heavily from the Apartheid Convention, which, as we all know, uses the language with the intent to maintain an institutionalized regime of systematic oppression and domination of one group over another. And the idea of gender apartheid would be to include gender too as part of the institutionalized regime of systematic oppression and domination of one group over another. So in Article 2 of the Draft Convention of Crimes Against Humanity, what we call for is the recognition of not only apartheid based on race, but apartheid based on gender. And in my conversation earlier in the morning, I spoke of the silencers in international law and that gender remains in the margins of international law. So how do we move what is in the margins to the center? And I think this is such an opportunity to make gender central to the draft Convention on Crimes Against Humanity. So the proposed definition would be the crime of gender apartheid, which refers to inhumane acts committed in the context of an institutionalized regime of systematic oppression and domination by one gender over another. And gender apartheid would codify the subordination of women in violation of the fundamental principles of international law. And so the three elements that I would like to raise here, why gender apartheid is different from and should be distinguished from gender persecution, is that gender apartheid references an institutionalized regime through laws and policies. And the totality of the chilling edicts, numbering over 100, targeting women and girls passed by the Taliban since August 2021 rises to the level of gender apartheid. And, I can go on speaking about the different edicts, whether it is the denial of education for women and girls, the ways in which women have been erased from the public sphere, where the way in which women's voices have been muffled, both in the private sphere as well as in the private sphere, and the ways in which the public flogging of women and the public beating of women for so-called moral crimes constitutes a level of gender apartheid, a level of a crime against humanity. So that is why I think it is important to name a crime that is yet to be named.
Well, that was a convincing answer. Thank you. I sort of took from that, apartheid kind of helps us capture the sort of like larger scale of sort of systematic gender persecution, the kind of ways in which it functions as a kind of institutionalized regime, and the general importance of bringing, I think your words were sort of gender from the margin to the center of international law. So thank you for that. My next question has to do with just the kind of concept of gender itself. So I'm wondering how you see the relationship between women and gender in the Women, Peace, and Security agenda. And I'm thinking here about arguments made by some people that, gender is often used kind of synonymously with women. It's sort of a stand-in rather than a broader concept that talks about both men and women and the different spaces that they occupy in relation to different social and institutional and political structures. And so, I kind of wonder what your thoughts are on that, the relationship between sort of gender versus women. And then also, where do gender diverse people, LGBTQ2S plus people fit into the agenda? And is there space for them? And I'm thinking here a little bit about some of the work, I think, that's come out in the last sort of 5 or so years that are talking a lot about sexuality, but also trans people and how they are perhaps missed in some of the work on women, peace, and security. So any thoughts on that would be wonderful. Thank you.
Thank you. So these are very important questions. Although given the paucity of words in the WPS agenda, in the WPS addendum, there wasn't really the canvas for me to be able to expand and elaborate more on that particular issue. Although, if you read the addendum very carefully, I do speak of the need to emphasize the importance of protecting women, LGBTQI, human rights defenders in conflict and post-conflict settings. As you know, trans women, LGBT, and other women of different gender identities are under threat during conflict and in post-conflict and pre-conflict. And human rights defenders are those who are really at the very center, the epicenter of post-conflict renewal and transformation. So written into the addendum is the need to address human rights defenders who are LGBTQI, as well as I think for the first time in any conversation on women, peace, and security agenda, I have written into this addendum the need to address what in the International Criminal Court's 2022 gender policy paper calls for, interpreting gender as socially constructed, acknowledging the violence targeting LGBTQI plus persons for deviating from gender norms, which constitutes crimes against humanity. And in January 2025, the ICC made a historic move by mentioning LGBTQI plus people in the arrest warrants regarding Afghanistan. So it's not only the women of Afghanistan, but the LGBTQI, the understanding of that women are not a monolithic, and that LGBTQI plus women are the most disadvantaged by the Taliban edicts, and that the arrest warrants need to address this. So in different ways, although I could not go into depth or detail in this addendum on WPS, by invoking the International Criminal Court's gender policy of 2022, as well as the January 2025 ICC arrest warrants, which call for the protection of LGBTQI people in Afghanistan, and then the reference to the LGBTQI human rights defenders in relation to the protection as well as the promotion of the work of women human rights defenders pre, during, and post-conflict. I hope I have to some extent, although it is not adequate, it is not sufficient, more needs to be written about this. And what I hope to do is to take every article, every paragraph of the addendum as it is, and enunciate it, elaborate it further as we address these nuances and these challenges in a more concrete and substantive manner.
Thank you. I did want to also leave some time for questions from the floor, but I'm going to move into another question if that's okay, and then maybe we open it up. Yeah, okay. So one of the things that I really appreciated about the addendum is that it discusses mass forcible transfers, which is obviously incredibly important given the times that we're in. And I wondered if you could elaborate a little bit on how, from an international law perspective, we can draw lines between claims by occupying and warring parties that they are evacuating people to save them. And then the question of forcible transfer that is actually about taking land or dispossession.
Absolutely. So there are many points in the addendum, whether it's mass forcible transfers, but also starvation as a crime against humanity, the deliberate starvation, intentional starvation, and the deliberate and intentional denial of access to humanitarian aid. So I see this as a confluence, the mass forcible transfers, the ways in which the intentional denial of access to humanitarian aid, the intentionality in starvation can all come together. So as many of you know, mass forcible transfers are the forced unlawful relocation of civilians prohibited under international humanitarian law, particularly Article 49 of the Fourth Geneva Convention. And this is considered a war crime and a crime against humanity, which includes expulsion through violence, coercion, or abuse of power aiming to displace populations systematically. Article 147 of the Fourth Geneva Convention defines the unlawful deportation or transfer of a protected person as a grave breach of the Convention, and further expands the definition of grave breaches clearly to include this as war crimes, among other acts. the transfer by the occupying power of parts of civilian populations in the territory it has occupied, or the deportation or transfer of all or parts of the population of the occupied territory within or outside this territory is in violation of Article 49 of the Fourth Convention. So very quickly, to look at how this has been used, we see that that Article 5D of the ICTY statute, the International Criminal Tribunal for Yugoslav, and Article 3D of the ICTR statute, the International Criminal Tribunal for Rwanda, and Article 2D of the Statute of the Special Court of Sierra Leone did enshrine the forced deportation of civilians. And the deportation of and ICC statute in Article 7.2D defines the deportation or forcible transfer of population as forced displacement of the persons concerned by expulsion or other coercive acts from the area in which they are lawfully present without grounds permitted under international law. So we see that in the former Khmer Rouge, leaders were charged by the extraordinary chambers in the courts of Cambodia with unlawful deportation or transfer as a grave breach of the Geneva Convention, as well as deportation and forcible transfer as crimes against humanity. And in 2009, the pretrial chamber of the ICC issued an arrest warrant for the Sudanese president, Omar Bashir, for his alleged criminal responsibility for, among other crimes, forcible transfer as a crime against humanity within Article 7.1D of the ICC statute. So I just wanted to leave the students with those examples. So it is now their responsibility to be able to apply this law the way it has been done before to what may or may not be happening at this moment in time.
Thank you very much. Do you think this is the time where we maybe open it up to some questions from the floor? Is that good for you, Dr. Da Silva de Alves?
Yes.
We have a question in the back. Do you have a microphone?
I think I can project pretty well. My question for both of you a little bit is, it's been 26 years since the passing of Resolution 1325, and I wanted to know, these kind of two questions in one. First, if there have been any national action plans that have stood out over these 26 years on their implementation of WPS. And second, if in this context of kind of freezing international law and advocacy and difficulty in that terrain for advocacy, if local action plans or regional action plans have been a more effective advocacy opportunity than national action plans.
Please go ahead if you'd like.
Okay, so that's a great question. So it has been 26 years since the WPS 1325, and 1325 was followed on its heels by 1820, followed by 2242 on CVE PVE, 1888, which was introduced by Secretary Condoleezza Rice, followed soon after by 1889, which was introduced by Hillary Rodham Clinton, the next Secretary of State. Why I am articulating these Security Council resolutions is because I want the students to understand that in the United States, this has been a bipartisan effort, that although we have now abrogated and repudiated our responsibilities under WPS, the WPS agenda was very much a bipartisan effort. And that is why the ways in which we have abdicated our responsibilities towards the WPS agenda remains a travesty, because 1888 and 1889 Security Council resolutions setting up both the office of the Secretary General's Special Advisor on conflict-related sexual violence were introduced by the United States. And much of the support for this office was provided by the United States. And Security Council Resolution 2467 calls for access to justice and articulates the importance of accountability proceedings that are survivor-centric and trauma sensitive. So with that prelude, I want to say there isn't a single national action plan that has fully complied with all of those resolutions. And again, I want to emphasize that 1325 was the very first, the seminal Security Council resolution that acknowledged that women are not only victims of war, but are actors and agents of peace, and are actors in conflict resolution and in peace building. And much more then followed, although not enough. And that is why the importance of this addendum, because the addendum looks at these new threats, while the Security Council resolutions under the WPS agenda looks mainly at women's bodies. You know, I have argued that there's almost like a fetishization of women's bodies, that conflict is only waged on women's bodies. And as I said in my earlier conversation, that women's minds are battlegrounds too. And we really need to address the kind of almost colonial patriarchal framing of the current WPS agenda. So most national action plans still follow in that suit, the counting of the numbers of women in the military, counting of the numbers of women in the different security infrastructure, rather than looking at the preventative pillar, the role of prevention. This is not about making war safe for women. This is about preventing, the prevention of war and conflict. And so, but what really comes to mind from the mapping of the Security Council resolution, mapping of national action plans, is that probably Canada and Ireland uses this moment in time to not only address these rising threats such as climate emergencies and weaponization of technology in still not in substantive matter, but articulates it in a very general term, but also addresses the fact that that residual aspects of colonial rule continue to inform the reading and the interpretation of the WPS agenda. So kudos to Canada on that. And Ireland too addresses this from the basis of how we have to bring a minority perspective to the readings and the interpretation of the WPS agenda. And when both Canada and Ireland came before the CEDAW committee, I have reminded them that their work now has to be one that needs to be followed by other states. And what can Canada and Ireland do to address these issues, the root causes of violence? The root causes of violence are these gender unequal legal systems, not only gender unequal, but gender and intersectional unequal legal systems. So how do we address the root causes through the WPS National Action Plan, rather than counting the numbers of women in the military? Thank you.
Thank you. I think we have time for one more question. I'll maybe try to say a few things at the end, just sort of in response to Alex's question, because I have a few things to say about Canada and its abandonment of the of feminist foreign policy, essentially, and the impact that I think that has on Canada's commitment to WPS. But if there's maybe one more question, why don't we take that now?
Hi, this is Elisa Yamamoto with the End Gender Apartheid Campaign. Great to see you, Rangita. Thank you always for your championing of this cause. I actually wanted to ask something maybe related to what you were going to raise, Colleen, which is this interface between feminist foreign policy and WPS. And of course, we have the upcoming ministerial conference for feminist foreign policy in June in Madrid. To the point of a post-colonial or kind of decolonial approach to these issues, what is the role of the Global South and global majority countries within the feminist foreign policy agenda in kind of relocating the center of power and kind of reconfiguring how we understand WPS in this space?
So excellent question. So the good news is that Mexico for a time, Chile for a time, because again, there has been some backsliding with the changing of the political order and the political regimes. But there are global South countries that have joined the feminist foreign policy movement. And I was in France, as you know, a couple of months ago for the Feminist Foreign Policy Symposium, where countries such as Morocco pledged their support to feminist foreign policy. So to have global South countries, especially Muslim majority countries, pledging support to feminist foreign policy is not only important, but non-negotiable. And again, even though I work very closely and admire the work of the feminist foreign policy movement that was started by my colleague, current colleague at the University of Pennsylvania, Margot Wallström, I do feel that there are some criticisms that have been made against feminist foreign policy that need to be addressed. I do not always agree with the criticism, but I do feel that they need to be addressed given the fact that feminist foreign policy is still seen as a Western concept and one that needs to grow out of this not only a top-down approach, but where top-down and a bottom-up coalesce. And I think we don't yet see that, the ways in which feminist foreign policy needs to be endogenous and dynamic in the and grow as a dynamic instrument in the global South. And the fact that the residual aspects of post-colonialism, neocolonialism continues to shadow feminist foreign policy. How do we decolonize the foreign policy? And as I see that we have another distinguished guest here with us. And I had mentioned Ireland before, and that Ireland has taken a major step in being the advocate to address the risks and the harms of AI-driven lethal autonomous weapons. And in their statement to the United Nations, Ireland did invoke the fact that some of the data that is used as training data in large language models that are used in AI-driven lethal autonomous weapons are also colonial and discriminatory in effect. And and specifically, Ireland uses the term that we need to decolonize the data that is being used in training large language models in AI-driven lethal autonomous weapon systems.
Okay, thank you so much, Professor Da Silva de Alves. I'm going to close it now, end things now, because I think we're a couple of minutes over and I recognize there's another panel that needs to get going. But thank you so much for your questions and for your attention and for listening. And thank you especially to Rangita for her thoughtful comments and really honestly for the incredible work of putting the addendum together and all of your other work on the Women, Peace and Security agenda. We're lucky to have you.
Thank you. Thank you.